I'm Drake Menning, and this is my video summary number 6 for Chapters 9 and 10. Chapter 9 talks about the law of contracts and sales. It talks about different types of contracts and the legal issues involved. Contracts are made between parties who exchange promises. The contract makes the promise legally enforceable. Contracts are important when doing business to keep both parties accountable. Many business contracts, such as those dealing with property, employment, and services, are governed by case or common law. Since many states have their own differing laws and rules, a uniform commercial code was adopted to give all states the same requirements for making sales contracts. There are many different types of contracts. An express contract is an oral or written promise, and both are legally enforceable. An implied contract is not necessarily spoken or written, but implied by the party's conduct of what a reasonable party would do or want in a specific situation. A unilateral contract is one where someone promises something in exchange for an act, while a bilateral contract is when two parties exchange promises. The difference between void, voidable, and valid contracts is also discussed. A contract is legally void if it contains an illegal act, and voidable if one of the parties involved has the option to withdraw from the contract for valid reasons. If it is not void or voidable and is enforceable and meets other specific requirements, it is a valid contract. When all the terms have been carried out as originally promised, the contract has been executed. The chapter talked about the 6 parts of a valid legal contract. Knowing these elements can help me in a future job by knowing if a contract someone presents is legal and enforceable. These parts are a legal offer, legal acceptance, consideration, general assent, competent parties, and a legal object. A contract begins with an offerer initiating an offer to an offeree. If the offer cannot be legally terminated and is not rejected, there is legal acceptance. For the contract acceptance to be valid, there must be intent shown by the offeree that is communicated properly, and the terms of the offer must be satisfied. The next element of a contract is consideration, where there is a legal detriment suffered in the bargaining process. There must be genuine assent where both parties are on the same page and there is no fraud or other misrepresentation involved. Both parties in a contract must be competent and must understand the terms and consequences of the contract. Finally, the subject of the contract must be lawful, or the contract cannot be legal and is void. There are some contracts that do not need to be in writing, but there are certain business contracts, such as real estate transactions, that do need to be in writing. When a written contract is made, any oral agreement that varies in those terms is not valid. While most contracts are between two parties, there can be contracts between two parties that benefit a third party, whether intentional or incidental. Learning about the details of business contracts and the different types of contracts can help me as I become an accountant. It's important for me to know what is legal and not in making and enforcing a contract with someone. A contract can become complicated, and the other party may not always hold up their end of the contract, so knowing my rights is important. Chapter 10 continues to talk about contracts. Several ways to terminate or discharge a contract are discussed. The most common way of discharging a contract is completing the terms of the contract. Parties can mutually agree to cancel the contract if they are not able to fulfill it due to something that came up after it was made. A contract can also be discharged if there is another condition or event involved that must happen for the contract to be fulfilled, and that condition is not met. If the contract cannot be physically be performed, or there is a legal reason it cannot be performed, a contract can also be discharged by impossibility of performance. If an unseen situation comes about that would make fulfilling the contract injurious or overly expensive, it can also be terminated. There is a breach of contract if one of the parties does not follow through with their part of the contract. There are remedies for a breach of contract, and that can include requesting monetary damages or non-monetary damages. Common remedies include cancellation of the contract, right to remedy, setting of additional time, price reduction, money damages, and specific performance. If a party has lost profits from a breach of contract, they may be awarded compensatory damages for their loss. Additional punitive damages can also be awarded to deter the breaching party from having this type of conduct again. If monetary damages are not a practical solution for a breach contract, parties may look to equitable remedies such as rescission or canceling the contract, or reformation, where the parties can make new terms. Another topic talked about is e-contracts. As they are becoming more popular, there should be remedies available to the buyer for defective goods, a form selection clause regarding disputes, a statement of how goods should be paid for, and other disclaimers and provisions to protect the buyer and the seller. Business contracts can be very detailed and complex, and as I enter the business world and may have to make contracts, it is important for me to know the detailed information involved in making contracts and under what terms myself or the other party can legally terminate a contract. Learning about a breach of contract is also important, so if another party does not follow through with a contract, I will know my rights and different options on how to follow through to settle. While contracts can help make business dealings fair for everyone by making the parties accountable, there are so many laws and rules involved that many people might not be aware of. So it will be important for me to fully look into a situation before signing a business contract so I am not taken advantage of and know my rights.